I'm Renata Hesse, a partner here at S&C and co-head of our antitrust group. Joining me today are my fellow partners, Joe Metellus, who's also a partner in our antitrust group with me in Washington, D.C., Matt Hurd, a partner in our M&A group and co-head of the firm's Healthcare and Life Sciences group in New York, and Laura Oswell, a partner in our M&A litigation group and co-head of the firm's FCPA and anti-corruption group, and she is located in Palo Alto. Before we dive in, if you have questions, please submit them by clicking the Q&A button at the bottom of your screen. We'll try to answer them if we have time, and if we don't have time for that, we'll follow up with you after the webinar and answer your questions that way. So we're going to start with Joe giving us an overview of the executive order and all that it contains. So I'm going to hand it off to Joe.
Thanks, Renata. So it's been nearly 3 weeks since the president issued his executive order on July 9th. I'd say that the premise of the order and the acts that it recommends emanates from the administration's view that the trend of corporate consolidation in America has diminished competition and resulted in increased prices, stunted economic growth, and suppressed wages. So it's a rather dim view of antitrust enforcement and competition enforcement over the last 40 years. The order sets forth 72 specific initiatives and directs or encourages more than a dozen parts of the federal government, both parts of the administration, the executive branch, and independent agencies, to take a more interventionist role in regulating competition and preventing what's referred to as unfair business practices. Some parts of the order apply across industry, no matter what the underlying businesses are. I'll mention two of those issues right now. The first is just a general directive regarding merger enforcement and a call in the executive order itself for the agencies to examine the horizontal and vertical merger guidelines, which apply across industries. Renata and I are going to talk a little bit more in depth about that in a few minutes. I'd say the other broad cross-industry concern has to do with what I'll call non-compete agreements that limit employee options for changing jobs and agreements between competitors in particular and affecting employee mobility. In addition to those cross-industry focuses, there are several industries that are specifically called out and have specific instructions regarding them. I'll just name the industries, and if you're interested in the particulars of any of the industries, we can potentially follow up after the webinar. But in general, healthcare, transportation, including air travel, rail, and shipping, agriculture writ large, internet service, technology, and banking. I'll also note that of all the 72 initiatives that are mentioned in the executive order, the president in his signing ceremony called out 3 in particular. 2 had to do with healthcare. One was limiting FDA rule or promulgating FDA rules that would allow states and tribes to safely import prescription drugs from Canada. The second that the president called out was rules that would allow hearing aids to be sold over the counter. And then the third broad issue that the president named had to do with non-competes, which is an issue that he pointed out that he'd spoken about previously when he was vice president. I'd say many of these ideas are likely to be implemented by the president's executive branch appointments, and as well as by the heads of independent agencies that he's appointed. I'll call out 2 personnel changes. Lena Khan is now the chairperson of the Federal Trade Commission, She has been very critical of the large tech platforms in her academic writing, and is closely aligned with one of the other Democratic FTC commissioners, Rohit Chopra, with whom she previously worked, who was also similarly very critical about tech platforms. And then very recently, the president has nominated Jonathan Cantor to be the Assistant Attorney General in charge of the Antitrust Division, and he too has a tech background of being, very, very critical of some of the large tech platforms. So there's my overview of the executive order, and I think I'm going to turn it over to Matt to talk about what this means for the M&A world.
Well, Joe,
Matt, I'm just going to interrupt you quickly before you start, just to add two things. So one is, you'll notice that what the president highlighted in his speech are what we used to call, somewhat quaintly perhaps, pocketbook issues, drug prices, hearing aid prices, things that really, wages for employees, things that really matter to everyone out in the country. And I think that was purposeful. I think he was trying to say antitrust can do something for you, citizens out in the world, and we're here to help. The other thing is that the order itself was I think really directed in some part to these executive branch agencies, the regulatory agencies, and was a signal to them that the president really wants them to kind of instill the culture of competition in the work that they do, and the regulatory processes that they oversee, and the regulatory approval processes that they direct. So sorry, Matt. Now I'll pass it off to you.
Not at all. Look, the executive order really is a grab bag. It's a very lengthy, detailed list of governmental priorities, and they affect specific industries in a very specific way, and that accounts for 65 plus of these items. There are a couple of zingers, if you will. There are a couple of items that relate to the larger substance of antitrust theory, as Renata and Joe will discuss. But it's a very specific list of governmental initiatives that the president expects to follow up on. Whatever you may think of the specifics, I think we have to agree that industry, the M&A bar, the antitrust community really does benefit from the transparency offered by the specificity of the order. Every single time there's a change in administration, we are in a situation of trying to predict, trying to anticipate, trying to wait for whatever changes will come in antitrust enforcement. And with this lengthy list, we have a bit of visibility into what people can be attending to. So with Trump, there was a very substantial delay in the evolution in visibility into his administration's approach, arising out of his delay in filling chairs, making appointments. President Obama was very significantly distracted by the demands of the financial crisis. Here we have, in the first, say, 6 months, a roadmap or a laundry list of what this administration cares about. And I think that's useful. So clarity is good. And now that we have it, we can start addressing some of these priorities in the context of deals. Now, most of these items will have no direct impact on M&A transactions. A liberality in importing Canadian pharmaceuticals is not going to have any direct impact on M&A. But for certain deals that are affected competitively by the specific products, typically generics, being imported, there will be some diligence issues arising out of that, and that will matter in the context of one specific deal, even though it will be virtually irrelevant across the platform of antitrust sensitive deals. Similarly, if seed companies are suing farmers over IP infringements, that's really not going to make a big difference overall to antitrust enforcement, but it will make a difference in the context of particular deals involving seed technology companies. 60 or so of the initiatives of the items are more or less evocative of diligence concerns, as opposed to any great substantive change in antitrust policy. So M&A people, the M&A community will really care about many of these items only to the extent that they target the specific business that's the subject of the transaction. And in most cases, this is going to have significance only for diligence, integration, and operations. Within the overall field of antitrust enforcement, though, we know that the agencies are going to be refunded. We know that they will, that accordingly scrutiny will increase. And on top of that, buried within the executive order are proposals to amend the vertical merger guidelines adopted under the Trump administration and the horizontal merger guidelines adopted under the Obama administration. Joe and Renata will talk about that. With that substantive change, with the procedural changes, the funding, the greater scrutiny, and whatever substantive changes offered by a rethinking or revision or modification of these guidelines, we will see some impact on M&A. Attention will be drawn to the exact actions that the parties will undertake to achieve merger clearance. I'm not talking about best efforts or reasonable best efforts for hell or high water. I'm talking about that plant. Are you going to divest it or not? That IP, are you going to license or not? Discussions on deals will get to the granular, and that's probably a good thing from the standard operating M&A perspective. And furthermore, as antitrust and as the law is decided by the courts and by the judges and not by the regulators themselves, there's going to be increased attention in negotiations to exactly how far the parties are going to be willing to go to either sue or be sued by the regulators and really make law, if required, to effect the transaction. And so you're going to see a gearing up of a litigation mindset, if you will, and increased discussions across the negotiating table about litigation strategies. Breakup fees only go so far. People will now focus on the P's and Q's of what exactly they're going to do to achieve antitrust clearance.
Thanks, Matt. So, there are many things going on in antitrust, and the executive order and the revision of the guidelines are only one or two of those things that's happening. So we have potential legislation going on at the Hill. We've got the international landscape. We've got changing personnel at the agencies, and then again, the potential modification of the vertical merger guidelines and the horizontal merger guidelines. And so Joe and I think we're going to talk a little bit about each of these pieces and kind of what you can really expect in terms of the arc of change, because there's a lot of consternation. Maybe that's not quite the right word, but a lot of activity and thought going into, well, what does this mean? What does this mean for transactions? What does this mean for my ability to get a deal completed? How is this landscape really changing, and how quickly is it changing? And I think each of these little pieces that I just mentioned, happen are likely to have an effect at different points in the spectrum. So, for example, Matt talked about the refunding of the agencies. That's an important piece of this component. The agencies are severely understaffed at the moment, and that makes it difficult for them to undertake a bunch of different investigations across a bunch of different industries, transactions, or non-merger conduct. So as the agencies staff up, they will have more capacity, and more capacity generally means more investigations and likely longer investigations. That, I think, is going to happen relatively quickly. With the guidelines, and I think Joe may want to weigh in on the guidelines point. That's a slightly longer term process, we think. And it also obviously isn't a change in law, which either Congress or the courts would have to effectuate. So Joe, do you want to talk a little bit about the guidelines maybe?
Sure. So as Renata said, the guidelines, even though they're very important in our world as antitrust lawyers, are not the law. The underlying laws are the same. But the first issue, the issuance of the guidelines was in 1968 by the Department of Justice, and it was designed to provide transparency to the business community about how the Department of Justice was going to enforce the relatively vague commands of the Clayton Act, which talk about blocking mergers that may substantially lessen competition or tend towards a monopoly. So that doesn't provide a lot of specifics to plan around. And so what has happened over many iterations is that the agencies have stated what their enforcement intentions are. And that document is an interesting document. I mean, over years, what has developed is not only is it seen as a statement of enforcement intentions about what the agencies are going to do, but it's sort of become a restatement of, I'd say, economic theory about when a merger is or is not likely to harm competition. And so it essentially reflects actual practice and the way the agencies historically have been viewing mergers, both on the horizontal side and even on the vertical merger side, which is less specific, I would say, about when a merger will and will not harm competition and lead to an enforcement action. Sort of a couple interesting things about the call in the executive order for the FTC and the DOJ to revisit the horizontal merger guidelines. In President Biden's remarks about the executive order, he had an interesting line where he said, 40 years ago, we chose the wrong path, in my view, following the misguided philosophy of people like Robert Bork, and pulled back on enforcing laws to promote competition. So what happened 40 years ago? It's about the same time that the 1982 horizontal merger guidelines were issued under Bill Baxter's leadership at the Department of Justice. And if that's what the president is talking about, undoing, that would be a relatively significant change in enforcement policy, because some of those ideas from the 82 guidelines have been incorporated in every subsequent iteration, regardless of whether it was a Republican or a Democratic administration. So if we're talking about revisiting, sort of the core concepts of the 82 guidelines, that could be a big change in enforcement policy. I think it's a different question whether courts will go along and rely on the horizontal merger guidelines as a sort of a restatement of actual economic principle in the same way they have for prior iterations of guidelines. If something very, not in line with historical practice becomes to be the new enforcement policy, the executive branch can bring whatever actions it wants. But the nature of the guidelines is sort of a down the middle of the fairway restatement of actually what the agencies historically have done. That potentially would be changed, and that'd be quite a significant change in practice in our world if that comes about.
And Matt, and then I want to draw Laura in here a little bit, because one of the things that we I think are starting to think about is as we talk to clients about longer investigations, more scrutiny, the inevitable question of how do I get to close on transactions happens, and there are lots of covenants, and they all kind of work together that parties enter into in merger agreements. And there's an outside date that people agree on, and that's typically guided at least in part by how much regulatory risk do you think a transaction has, or how much of an investigation you think it's how long do you think it's going to take to get your regulatory approvals. So I wonder if Matt, you might mind commenting a little bit on those covenants, and also how those covenants interrelate as you start to shift drop dead dates and the risk allocation. How does that impact financing and things like that? And then maybe we can kick it over to Laura to talk a little bit about how the kind of specter of litigation plays into all of this as well, and how companies can be better prepared for at least to both demonstrate and then eventually actually litigate with the government if you feel like they're taking a position that's an unreasonable one from the perspective of existing law.
Right. So let's just unpack the toolbox. The first thing, as I said earlier, regulatory break fees only go so far in managing risk. They are better suited for more generic, atomized concerns than they are for specific regulatory change. With greater enforcement and greater change in the substance, I see longer periods between signing and closing, later drop dead dates in the language of M&A. During that period, I see the parties being subject to much more specific commitments about what they are going to do, conduct remedies, divestitures, et cetera, and much more granular covenants calling for who has to do what in the context of getting clearance. I think that discussion will naturally incorporate the parties' willingness to sue and be sued. And we've been in eras like this before. The late 90s were an era of very active, and the early noughts were a period of very active antitrust litigation that really guided M&A transactions. And accordingly, you had longer drop dead dates, much more specific covenants. And I think we're naturally going to come back to those mechanics of managing risk as between the two counterparties. Longer drop dead dates obviously means that you have to keep financing open longer. So for very large deals or for private equity driven deals, you have the possibility that the longer period will drive higher financing costs. We're in a very low cost, money is virtually free today for the big acquirers. So it's not at the moment an issue, but it is dollars and cents that feed into valuation. I really do think we're going to be going back to the time, it's very familiar to us, but we go back to the time where we really think about the litigation dynamics of antitrust enforcement as opposed to the econometric or the political. And that's an area where Laura really leads part of our practice.
Thanks, Matt. Yeah, I would just build off of exactly what you have said, to this point, which is what this really means is that it reinforces a level of discipline in terms of how you negotiate the deal, being very specific about what you are willing to do in terms of the business, divestitures, and the like, and also in terms of your litigation strategy. And while that may be a slight change from the more relaxed practice that some may have had to this point, where you had some degree of certainty about how antitrust regulatory clearance would work, at least in the United States, it's not a bad thing overall. And it's probably there's some benefit to that greater level of discipline across the board. And so when we think through that, as Matt said, that really means, having litigation front of mind, which, from my perspective is always a good idea, but might not be something that on the deal side people are as excited about. But if you start with kind of that idea in mind, that you may be put in a position where you need to litigate, an antitrust clearance, it really gives you the opportunity to think thoroughly at the outset about, what your competitive rationale is and how you build that. And if you kind of build that in to, how you approach the deal, how the deal is signed up, what the terms are, and then when you get to the clearance process, approach that process more with a litigation mindset in terms of how you're responding to the relevant regulator, what you're providing, how you're presenting your story, instead of treating it as an exercise of, they've asked for this, we're going to give them this information, and not thinking strategically about how those communications are going. I think that can solve a lot of this. The worst possible thing is to be caught at the end, surprised to find yourself in a lawsuit. If you start from the beginning with that expectation in mind, a lot of this planning can be done up front. And I think one of the most important things that Joe and Renata have said about this process is that, the law is the law, and the guidelines are there for a helpful purpose. But we all know, and the government knows, that those guidelines are not the law. And so one of the things that I would think about in going through the clearance process is presenting, your deal, your information in a way that makes your relevant regulator, the folks that you're dealing with, not want this to be the deal or the case where they test out some of these maybe new principles that we'll see in the merger guidelines. And so while it feels a little uncertain to have these guidelines in flux at this very moment and not know how they're going to come out, you have the law to rest on. And so you do have kind of what you need, I think, to put together your strategy, to be prepared as you go in and speak to regulators and share information with them, to make it clear that you've thought through this case already. It's not that the guidelines don't matter, but in a situation where we're not sure what they're going to be, there's still a readily, kind of easy approach to how you would go in with this information. And as a practical matter, one thing that we think about sometimes is, when you introduce litigators into the process, in my view, the sooner the better, at least on the internal side. But then also, when you're speaking with your regulators about a transaction, kind of when do you make it transparent to them that you have litigation counsel involved, and not to present an aggressive approach, but more just to communicate clearly that you've thought through the legal issues here and are prepared to litigate. And just circling back to where Matt left off, being prepared and aligned with your counterparty as you go through that process, kind of from what you've agreed to in the deal, how you've discussed the approach, makes this A, a lot easier, and B, a lot stronger position when you're dealing with the regulators and talking through kind of how you're thinking about the antitrust questions. With that, I'll turn it back to Renata for any closing remarks.
Thanks, Laura. It doesn't look like we have. Oops, I just got a question in the queue. So this is a good question, which is relevant to it. Do you think the FTC, DOJ are willing to go to court and lose? In other words, do you think they're happy to take a flyer and try to establish a new precedent? So I was actually just talking about this morning because of some comments that Chair Khan made at the hearing yesterday, where she expressed something about the timidity of enforcers because they were about filing cases because they were worried about losing. And I've always said, that losing does have consequences, right? You can make bad law when you lose also. So I do think it's going to be important for people to think about that question. I think they will probably be a little less timid and a little less worried about it. So I expect we will see them at least threatening to test new theories, and that parties are going to need to decide whether or not they're going to be willing to say, okay, this is a new theory and we don't think the law supports it, and so we're going to actually test that out in court and see how it comes out. And then, one other question came in about kind of when do you know in the process when you're headed for litigation? It's sometimes a little hard to tell. Getting a second request does not signal that you're headed for litigation. But I think as you get through the process and negotiate the second request, you start to get the feeling that, maybe they have a resolution in mind that you don't think is reasonable, and that that there's not, a meeting of the minds happening between the authority and the parties in terms of what they want. And I think there's a lot of careful listening that has to happen at that point. I remember being in the agency, and Joe may have some thoughts about this too, and feeling like we were signaling pretty clearly that we were not very happy with something that was going on, and the parties really just didn't seem to get it. So it's really, I can't emphasize enough how important it is to have open lines of communication, not a lot of antagonism, and to really listen to the agencies, because they do try to signal what they're thinking, where they're going, and what their concerns are about. Since we're at the top of the hour, one thing I wanted to just close on and emphasize from what Laura said, and then I'll let others jump in if they have closing remarks too, is preparation is really, really important. The number of times that it's made a significant difference to me as an enforcer when somebody has come in and has been able to explain why they're doing a transaction, why certain conduct is important, why it makes sense, why it's not harmful, and being able to do that and being able to be clear that you've really thought it through, that you're not kind of making up excuses for something that is otherwise harmful. It goes a very, very long way. So careful thought and planning during the at the beginning, before you get to the point when you're in with the agencies, is incredibly, incredibly important. And then Laura just added the whole litigation piece to that, both litigation between the parties, which we definitely don't like to see, but is a possibility, and then litigation with the parties and the government. So I don't know if anyone has any closing comments. We've got a couple more questions in the Q&A, but I think we'll try to answer those offline. Joe, Matt, Laura, any closing remarks? Okay. Well, thank you everyone for joining us today. If you have additional questions, and we will get back to those with questions in the queue that I didn't get to, or want to learn more about us or our practices, please visit our website at www.solcrom.com. We really appreciate you taking the time with us today. Thank you.